medical treatment of the person, or for removing the life-supporting equipment from the individual leading to death. Arguments as presented by the parties. During the hearing of the case, the arguments were presented by all three parties. Here are the arguments presented by different parties. Arguments as presented by the petitioner. The petitioner made the contention that the idea of preserving individual autonomy was embedded in the right to privacy, and that it also played an important part in the definition of liberty. The argument made in support of this perspective was that using advanced medical techniques to keep a patient alive in a persistent vegetative state prolonged their pain and suffering and allowed for an infringement on their autonomy and dignity. The petitioner additionally asserted that the right to live and die with dignity were interlinked. Moreover, it argued that a person could not be compelled to accept medical treatment against their will, and that it was their right under common law to decline any undesired medical treatment arguments as presented by the respondent, i.e., the Ministry of Health and Family Affairs, submitted a counter-affidavit in the court and stated that the ministry found it highly unfavorable to regulate euthanasia, as the need for euthanasia entirely depends on a case-to-case basis where uniform laws or regulations cannot be made. It was further argued by the respondent that under Article 21 of the Constitution of India, the right to live with dignity is included, but the right only includes the proper availability of food, shelter, and means for treatment for any health ailment. Hence, they asserted that the right to die with dignity does not form a component of the right to live with dignity. Arguments as presented by the intervener. In this case, Society for the Right to Die with Dignity, a society registered in Mumbai since 1981 by one of the social activists, Minu Masani, filed an application as an intervener. The Supreme Court accepted the intervention of society. The intervener submitted the affidavit in support of euthanasia. It was stated in the affidavit that there is a need to have a mechanism which can ensure a calm departure of an individual from life, leading to less pain and suffering. It further stated that freedom of choice also includes the freedom to choose whether to live or not to live. This freedom entitles the person to choose death rather than being in a state of irrecoverable ailment. Moreover, the intervener also advocated the living will concept and attached a sample of a living will with the affidavit filed in the court. Opinion of the judges. In this case, the Supreme Court delivered its judgment on 8 March 2018. The judgment by the Apex Court included 2 opinions of the judges, namely majority opinion, concurring opinion. The majority opinion was provided by the then Chief Justice of India, Justice Deepak Misra. The majority opinion was also cited on behalf of Supreme Court Judge Ajay Manikrao Kanwilkar. On the other hand, a concurring opinion was provided by Justice Dhananjaya Yeshwant Chandrachud. The majority opinion of the judges, the then Chief Justice of India, Deepak Misra, authored the majority opinion. He focused on one of the issues of the case, which stated whether there exists any right provided to the individual for stopping the medical treatment of the person or for removing the life-supporting equipment from the individual leading to death. Justice Misra opined that this question has diverse aspects dealing with legal issues, questions on ethics, morality, and societal norms. There is also a huge potential for abuse of such rights. Citing the precedents, Justice Deepak Misra writes that, initially in the case of Prathanam Varsar, Union of India, 1994, the issue of whether the right to life guaranteed by Article 21 also includes the right to die was raised. When the constitutional validity of Section 309 of the Indian Penal Code, 1860, was challenged, the case was handled by the Apex Court by drawing a parallel among different fundamental rights. Moreover, according to Article 19, the right to free expression includes both the ability to speak and the ability to remain silent. Similarly, the right to not live is also a part of the right to live under Article 21 of the Indian Constitution. As a result, Section 309 of the Indian Penal Code 1860 was declared unconstitutional. However, just a year after the judgment of Prathanam Varsar, the Union of India, 1994 was announced. It was challenged in the case of Jian Kaur v. State of Punjab, 1996. The argument was that someone who aids suicide is only helping to uphold Article 21 of the Indian Constitution p. Prathanam was overturned by the 5-judge panel. It was determined that p. Rothenham made the wrong verdict by relying on the analogy that certain other fundamental rights include the right not to, as the right not to speak is a covert act,